Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic, can non-competes be pro-competitive? An economist's view. By name, non-competes restrict competition. These contractual agreements, used most frequently to restrict labor markets, however, have less nefarious motivations and have traditionally been viewed under the rule of reason. In this episode, we take a closer look at non-competes from an economist's lens. Joining me today is my co-host, Anora Wong. Hi, Anora.
Hi, Christina.
So, pro-competitive non-competes. Why are we talking about it?
Well, there is immense interest in labor antitrust issues, but there seems to be an underappreciated view that specifically with non-competes, it's a form of a contract, as you said. It's commonly used. It could go back for a long time, and it even has been upheld many times in court cases. So it seems like non-competes can make some intuitive economic sense, but we're just not really getting that. So today we're going to find out why are non-competes pro-competitive, at least sometimes.
Great. And who do we have to speak on this topic today?
Our guest, Dr. Paul Wong, is an economist and director at NERA, which is short for National Economic Research Associates, Inc., which is a consulting firm. Paul is a member of NERA's healthcare and life sciences practice, as well as NERA's antitrust and competition practice. Paul has experience on a wide range of antitrust and healthcare matters. Paul has written extensively and also teaches economics at the University of California, Riverside. Paul received his bachelor's degree from UCLA and then his MA and a PhD from Stanford. Paul is an active member of the ABA's antitrust section. Paul is a recognized economist and a rising star inside the antitrust board. We're very lucky to have him.
Wonderful. Well, without further ado, Paul Wong, welcome to the program.
Thanks, Anora. Thanks, Christina. I'm happy to be here.
Yeah, it's our pleasure. Paul, let's just start off with a recognition that our Curious Amalgam has previously covered labor issues and antitrust in general, and we specifically discussed the no-poach, I think, in episode 108. So on a basic level, maybe you want, save us some confusion. What's the difference between no-poach and non-compete? How are those two concepts different economically?
Yeah, that's a good question to start off. So no poach and non-competes are both obviously labor market issues. I think of no poach agreements as being different because they're horizontal. Right? Typically, it's two hiring firms making an agreement, whereas a non-compete is more of the vertical variety. Right? It is a hiring firm contracting with a worker, so they're different entities, and so the economics of those are a bit different. Certainly, there are some shared concepts, ancillarity for one, and this sort of notion that these agreements are very tailored to the circumstance or the individual or the job function. And I think we'll talk about some of those shared concepts.
Right. And the point that non-compete or no-poach, one of them being vertical and one being horizontal, that seems to be a significant point. And why is that economically?
Well, I guess two reasons. From the economic perspective, right, that relationship's different. The rationale in the vertical lens is going to be very different in terms of economic issues and things you're trying to tackle than in the horizontal sense. I think on sort of the other side of it, the legal side, it's recognizing that economic difference.
Yep, I do agree. In antitrust, we seem to make a big point about what is vertical and horizontal. And so what if I want to get the cleanest economic story of non-compete? What would it be? How do I tell that economic story to a judge or to a layperson? And when does it when it's not clean anymore? When does such a non-compete agreement become complicated?
Yeah, another great question, and I think we should sort of set the stage a bit. So, in the basic sense, what is a non-compete? A non-compete is where a worker joins a firm and agrees at some point in the future, if that worker were to leave the firm, she would not compete for a period of time, right? And not compete directly with the firm she previously worked for. Where it gets complicated is one, as I said, these are tailored contracts. So every non-compete is different. There are going to be limitations on non-competes. The job function is going to be different. What the basic agreement might look the same on paper, but what it actually does is a really potentially very complicated economic question. And to list a few other, tailoring issues with it, right? There could be product market questions, there could be geographic market questions, there could be questions about time frame, could be questions about remedy. All of those are context and fact specific that make it a complicated issue.
Yep. So non-compete, basically, me as a worker joining a firm, agree not to compete for a period of time when I leave, and then I would think that's sort of like a relation-specific agreement that I it's sort of part of the bargain, right? That I agree to. But there are so many voices about antitrust concerns over it. And which is understandably, but let's unpack that a little bit. What are those anti-competitive concerns about that?
Well, a couple. I think to start with the end, right? If you look very narrowly at just the end when the worker tries to leave, right? It's in the name, non-compete. Right? The worker is stipulated by the contract to not compete with her prior firm for a period of time. Right. That within that small box, it is probably, or I shouldn't say probably, it is a restriction on competition, at least for a period of time and for a particular circumstance.
Right.
I think, as you pointed out, there's sort of a lot more to it if we zoom out a bit. And I think that's probably where we should head and talk about the economics a bit.
Right. But still, it's a very common form of contractual agreement, right? It goes way back, I take that.
Yes. So, and maybe a plug for the section as a whole. I was a member of a group that did a sort of very long policy comment last year on non-competes, and then there's been quite a lot of thought about this. And one of the things that comment has is sort of a detailed history. Right, this goes back. Non-competes go back to 15th century England, and you could think of kind of the archetype case for a non-compete as sort of like an apprenticeship. Right. So yes, again, at the very end, when the non-compete becomes enforced, there is a restriction on competition, but it might facilitate some sort of investment like an apprenticeship where there's a very long training period. And I think for a long time, that's the thing that's been recognized as the potentially beneficial thing.
Yeah, that seems to be very straightforward, right? Apprenticeship, and it comes with a sort of some strings attached. You cannot compete for a period of time after you graduate. And then it seems to be beneficial, right? It seems to be at least facilitating this sort of apprenticeship in the first place. Isn't that right?
Right. So, we have, 6-7 centuries of sort of recognized case law now on the fact that these sorts of agreements can facilitate investment. So it could be an apprenticeship and it could be very valuable training. These agreements more modernly come up quite a bit in intellectual property cases, right? So if you have trade secrets that are not necessarily well protected by other intellectual property protections, namely patents. You still might need some additional, I guess, contractual restraints to facilitate that investment. Also, skilled workers, and that's probably related to apprenticeships, but you see, I think, a strong rationale for these sorts of agreements in high-skilled labor. And I think we'll talk about a bit, particularly healthcare is one that's been studied recently. Physician markets. Physicians are highly skilled. It's a interesting labor market where these sorts of agreements actually can facilitate some investment and do some good, albeit there is a restriction kind of potentially in the future on competition for a period of time.
Right. But if going beyond the apprenticeship context, if a worker wants to leave his or her firm and then establish him or herself as a competitor, seems to be the case that if we just remove the non-compete, which is arguably a barrier to entry, there will just be more competition. And then there would just be more freedom of a livelihood. One would say, but is that a view that you disagree? Is that because that seems to be very intuitive?
So this is where I think most economists would agree with me. You might see a momentary blip in competition. So, right, if we eliminated all non-competes everywhere, sure, you'd probably see a bit more entry. Just like if you eliminated all patents everywhere, you'd probably see a bit more entry, right? I think the worry with that sort of policy and the economics of non-competes really is about a dynamic effect over time. So sure, in the short run, you might facilitate a bit more investment. Again, what these are really helping support and helping back up is potentially very valuable investment. And that has a payoff over time. That's the thing that you risk, I guess, potentially discouraging or even preventing with such a policy. That's the place where, very narrowly at the very end of a non-compete, yes, it restricts competition, but there might be a very, very long window where it's facilitating investment that outweighs it. And I think that goes back to, and this is why this is a vertical relationship. This is why it falls under rule of reason, is there's well understood, there's a sort of strong trade-off here. And often that trade-off can be beneficial.
I agree. And I think that's very insightful to look at sort of like over a longer period of time and then views it as a dynamic process. But as you said, it's very much, a non-compete can come in different shape and form, and it could limit perhaps 6 months or 3 years. It could be structured in different ways. So I guess that goes to your point that this whole thing should be judged in the rule of reason, under the rule of reason, and it's very much depending on the specifics, right?
Yeah, and I think maybe, a couple examples, and I'll probably come back to the apprenticeship model a couple times, but that's a good example. So what would typically happen under an apprenticeship? A young worker with no experience might come in under a master, right? At that time, the facilitating that recruitment and that sort of relationship, you might, to facilitate some trust and some understanding, agree to a non-compete, right? And with apprenticeships, I guess it probably depended even historically on how difficult the skills were, etc. But there would be a period of time where that young worker would learn under that master. And the incentive of the master to actually kind of provide the training and provide the secret sauce, if you will, is some protection that, hey, my worker's not going to come, or my apprentice isn't going to stab me in the back, at least without some notice, right? And so, again, to return to the two concepts quickly, ancillarity, there's got to be some investment or some benefit that it's driving, and there's some tailoring on the back end, right? These non-competes don't go on forever, really, in any circumstance.
Yeah, I think that's really Yeah, that's really important as well. So there has to be some investment or sort of interest that's being protected, right? What are some other types of interest that's sort of legitimately protected by non-competes? Could you give us some examples or categorical inventory of these interests?
Yeah, and I should note that at least in the U.S., uh, this varies drastically by state. So what is recognized is going to be different in each state and across the country. But common ones, trade secrets, and are a big one. Right? There's certain know-how. Think of like Coke's secret recipe or something, right? There's certain know-how that isn't or can't be protected by other means. You might want some protection as a firm in your relationships with your workers to protect that from being stolen. Or I guess appropriated is probably the more appropriate term.
Mm-hmm.
To list a couple others, incentives, quality, reputation, customer lists. I think economists would probably group a lot of those together. But again, you can think of there might be special things a firm does, or special customers a firm serves, or special customer relationships the firm facilitates that we'd want to that a firm might want to protect in a relationship to facilitate again that firm to worker investment. And last, there are other physical investments where there's some coordination required. So if you think about team building, there aren't non-competes in sports, but think of sports, right? If you have a baseball team, you need lots of different types of players to coordinate and recruit them all. And you might want some protection to make sure your workers aren't jumping ship left and right, and you're able to coordinate that team more effectively.
I think that's absolutely right. You want to protect the incentives of either the investor or also who it might be able to join the sort of the investment and then be trained to become a skilled worker. So I do understand that. But I think you mentioned earlier that a competition concern is probably more prominent towards the end of the tenure of a worker if there is a non-compete. If that's the case, how could a non-compete be designed sort of to minimize that competition concern?
That's a good question. So I think first I'd point out that, I think a lot of the recent policy interest in non-competes has to do with settings where that investment period isn't necessarily as big or as substantial. So in particular, low-income workers. I think there's a lot of questioning about non-competes there. And those are less clearly sort of high investment settings that more generally we're talking about. The other thing is really how long does it last and is it tailored, right? So in a particular job function, you might specify a non-compete to say only in a certain sort of pretty narrow product market or only for a year or 2 years. Those restrictions are fairly minimal. I think there's certainly less competitive concern and there's sort of the balancing of is the investment going to outweigh that?
Is buyout sort of a way to like as a structure, as a design of the non-compete as a good thing, sort of like providing an option for a worker to get out of the non-compete?
Yes. And I think some regimes, I won't be able to list them off the top of my head, but I think in certain states and certain regimes, that is part of the law, right? Non-competes are able to be bought out and able to compensate for the kind of lost investment or the risk that departure of a worker presents.
Right. I think this all goes back to your point that this is sort of like a general, comprehensive, dynamic trade-off that we're looking at, and it should be judged under the rule of reason. That makes good legal sense as well. I just want to make sure that's also how economists think. Again, let's perhaps take your example of physicians, and then talk about the benefits of non-compete and probably how that can outweigh the restriction on the worker down the road. But what's an example of a case where the benefits are actually small and then the restriction is not so proportional to the interest that sought to be protected?
Yeah, I think probably an example of where the trade-off tips towards preventing them or sort of stopping non-competes, and one where it tips towards continuing them. Those are probably illustrative for the audience. So first, I think I'd point to, particularly in Washington State, there's been a number of cases, investigations brought by the Attorney General about low-income workers. You can think of your kind of baristas or your sandwich makers. Right? There's probably not much, or we would generally think there's not much skill in that relative to, say, physicians, where you have to go to school for years and years on end. In that case, the investment's probably minimal, and in particularly the Washington State case, the Attorney General had pursued those and got some of those non-competes removed from these low-income worker employment relationships.
Yep. That's a good contrast. I just want to focus on one more thing. I think several times you mentioned that it's very much depends on which state it is, what state enforcers would recognize as a legitimate interest to be protected. But and that's something that we want to focus on just in a minute. But on a federal level, what was the case? It's still a simple contrast between barista versus physicians, or is it something? What's the status of federal enforcement on non-compete?
So first, to be clear, there is no federal universal regime. Right? Mm-hmm. There are no federal rules as to when non-competes specifically can and cannot be used. Now, non-competes can certainly fall under other law, in particular antitrust law. They are contracts, so they potentially restrict competition. Right? Certainly, they could fall under the Sherman Act, and that's the one where we do see antitrust cases related to non-competes. But I guess within that realm, I'd say typically they're going to fall, if they do come under antitrust law, they will be rule of reason, and they're going to be sort of fact and context specific. So there is no one-size-fits-all federal policy for non-competes.
Right. So that even makes more sense why the most active enforcement or the most development or variation is on a state level. So unpack that a little bit. What is that variation like? Is it historically formed? Is it like certain states recognize certain interests more more dearly than the others? Just unpack that a little bit for us.
Right. So I think, going back while we have said, these agreements have been allowed and sort of upheld for centuries, there is also the notion that, people have a right to a livelihood. And so as more sort of historical circumstance than anything, certain states have just said, look, non-competes are null and void. They're not enforceable. And there's a small handful where that is pretty much through and through. California, North Dakota, and Oklahoma are the most notable examples. Most other states allow them, and really the question is in some circumstances they've banned them, and in some other circumstances they're permitted. And what that is, and there's really so much variation depending on the state. Some states ban low income, some states ban non-competes in certain industries. Many states limit the length of time or the notion of injunctive relief under these. There is no one-size-fits-all rule.
Yep. And even within the same state, the rule seems to be changing, right? Like, several actively enforcing states, they're also developing their jurisprudence, in a sense, their policy on non-compete from time to time. Is that right? Please give us some summary of what's happening on the most active states enforcement level.
Yeah, so most of the policy interest at the moment, and where things have moved fairly significantly, has been sort of in the low income space and the worker positions where there's probably not so much investment. So I think to list a couple: Maine, Maryland, New Hampshire, Washington. I may be missing a couple, but there's a number of states that have banned non-competes for low-income workers, and what that threshold and what the definition of low income is varies. I think there's other states that have focused on specific industries. So to call out one example, Florida banned non-competes for physicians, but only under certain circumstances. And there was a sort of market structure test related to the ban as well. So some states have taken sort of more tailored approaches. I guess the third class is there is maybe one example, DC recently, that sort of did a more wholesale ban on non-competes, but the drastic shifts, sort of banning them everywhere, has been much fewer and far between. Most of the policy work has been a bit more targeted.
Paul, this is, I guess I would expect high variation across states. It's a long-standing practice with many common law variations, statutory variations, and a coalescence of labor market issues, antitrust, and to your point, sort of economic, motivators and economic policy. Before we move on to sort of the personal questions, what are you working on? What are economists working on in terms of ongoing research in the non-compete space?
It comes down a lot, I think, to that trade-off, right? Economists are really looking for what are those empirical tests and what are those indicia we can use to figure out when these investments are actually warranted and when they're not. And I think that, again, because it's difficult to have a one-size-fits-all policy, there's still a lot of economic work in figuring out, okay, they may work for physician markets, they may not work for coffee workers. What about high tech? Or what about manufacturing? There's still a lot of ground to cover, both in theory, because it could go either way, and then empirics. Can we really test this for specific industries or for specific circumstances? And then how, as economists, can we extrapolate and generalize that?
Great. So I guess for our listeners who want to do what you do and explore these very interesting hypothetical questions with real data, do you have any advice for young professionals or young economists who are looking to do what you do?
Yeah, I think this would extend even to young attorneys, certainly to economists. Right, we all have to be experts in something, and I don't mean necessarily literally experts that would testify in court. We all have to be knowledgeable about certain things, right? And So obviously, probably most people listening are experts, quote unquote, in antitrust. But I mean a bit narrower than that, right? So pick some topics you're really passionate about. It might be non-competes, it might be price fixing, it might be a particular industry. I think we all need that expertise because that's where we find our comparative advantage, to use some more economics lingo.
Great, Paul. So we ask all of our guests this question, which is to tell us something about yourself that we wouldn't know about you if we only knew you professionally.
That's a tricky one. I guess I would say, personally, at the moment, I'm sort of up to my eyeballs in wrangling children because of a year through pandemic. So I have 3 young kids. I love them dearly. But when I'm not, I guess, nerding out about antitrust, I'm chasing my kids around. And I probably had the lack of foresight to live across the street from a park. If I'm not on the phone, I'm probably at the park across the street.
How old are your kids?
At 4, 2, and 2 months.
Wow, so you have your hands full.
I've got a handful at the moment.
Yeah, well, that's a fun age, but yes, that's a handful to have certainly during the pandemic.
Yes, it's been definitely a learning experience having kids underfoot while we try to work.
Great. And now for our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So, Paul, I'm going to ask you to pick a number 1 through 25.
13.
13. Okay. If you couldn't live in the country in which you presently live, what country would you like to live in?
Well, I'm not sure. I guess I would live in Hong Kong. It's not its own country per se, and I won't step on all of those issues. But that's a place that I've spent a little bit of time I really like, and yeah, that'd be my choice.
It's a bustling, wonderful city, so I can definitely understand that.
It is. I could also crack the joke. I live in California. I thought maybe California is its own country, but
not until that fault line, officially makes it official. Well, Paul, thanks for joining us today in Our Curious Amalgam, and to our listeners, thanks for dialing into this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.